All right, so this is the Tuesday, March 16th meeting of the Assembly Judiciary Committee. I'm Mike Fewer. I'm the chair of the committee. We do not yet have a quorum, but we will convene anyway to begin. We recall that the rules of this committee are 2 witnesses on each side, 2 minutes each. We have our colleague, Ms. Skinner, joining us imminently in lieu of our colleague, Ms. Evans, who's unable to join us today. And we have Assemblymember Hayashi here with us, and she will proceed with Item 1, AB 1596. Ms. Hayashi, welcome.
Good morning, Mr. Chair and members. I'm here to present AB 1596. This measure seeks to protect victims of domestic violence. AB 1596 seeks to maximize the safety of those individuals who are protected under multiple protective or restraining orders. Current law requires that criminal protective orders supersede other protective orders, and oftentimes a criminal protective order will only include a don't harass or batter the victim order and may not provide the victim with higher protections they have been provided with under the full restraining order granted by another court. AB 1596 was simply clarify that most restrictive protective order prevails and shall be enforced. I have accepted the committee's recommended amendments to remove the section of the bill that deals with emergency protective orders, and today I have Ms. Tracy Kenny representing the Judicial Council in support of the bill.
Thank you very much. Ms. Kinney, please.
Thank you. Tracy Kenny on behalf of the Judicial Council in support of AB 1596. This will clarify the law on enforcement of protective orders. Most commonly, under our current rule with the criminal order taking precedence, we have problems when a criminal court order, as described by Assemblymember Hayashi, has a limited amount of protection because the criminal court's order is only for the purposes of protecting the integrity of the criminal proceeding, and they may not believe that more protection is necessary for the victim. However, the victim still retains the right of any citizen to petition the family court for further protection under the Domestic Violence Prevention Act. If the family court issues a fully valid order under current law, it's not enforceable if it conflicts with the criminal court order. AB 1596 will resolve that inconsistency and ensure that both orders can be read together to provide the fullest protection and the fullest effect of the court's orders to the victim. For those reasons, we ask for your aye vote.
Thank you very much. Are there any other witnesses in support? Are there any witnesses here in opposition to this bill? Seeing none, before we entertain questions or comments from members of the committee, we now have a quorum. Call the roll, please.
Fear.
Here.
Tran.
Here.
Brownlee. Skinner. Hagman.
Here.
Jones. Knight.
Here.
Liu.
Here.
Monning.
Here. Okay, we have a quorum. Is there a motion to approve the consent calendar? Is there a second? Second. It's been moved and seconded. Call the roll, please.
Fear.
Aye.
Fear aye. Tran.
Aye.
Tran aye. Brownlee. Skinner. Hagman.
Aye.
Hagman aye. Jones. Knight. Knight aye. Liu.
Aye.
Liu aye. Monning.
Aye.
Monning aye.
Thank you. Mr. Knight really means it. That's good. All right. Now, having done that, let's proceed to questions or comments from members of the committee for Ms. Hayashi or her witness.
Very briefly, if I may.
Yeah, Mr. Tran.
Thank you, Mr. Chairman. First of all, thank you for bringing this very important piece of legislation to the committee and to the state as well. I do have an issue or clarification if the Judicial Council or the author can help us out. For civil protective orders, what is the standard of proof or burden? Well, what is the legal standard then? Is it preponderance or is it beyond a reasonable doubt?
It's preponderance. It's a civil standard.
Okay. Are there any concerns or issues during your discussion whether the standard is low or it's too high or is it's inconsistent with the criminal standard?
The criminal standard isn't really a beyond a reasonable doubt for a protective order. It would also be a preponderance standard, so we think that those are consistent.
Okay, very well. Thank you.
Thank you, Mr. Tran. Other questions or comments from colleagues? Seeing none, Ms. Hayashi, do you wish to close?
Respectfully ask for your aye vote. Thank you.
Thank you very much. Is there a motion on this bill? So moved. It's been moved by Mr. Monning. Is there a second? It's been seconded by multiple colleagues. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Skinner? Hagman? Hagman, aye. Jones? Knight? Knight, aye. Liu? Liu, aye. Monning? Monning, aye.
Congratulations, Ms. Hayashi. That bill is out. Next, we'll hear from Ms. Ma, AB 1656, item number 2. Ms. Ma, welcome.
Thank you, Mr. Chair and members. Good morning. Before I begin, I want to let the committee know that I am accepting the proposed amendment in the committee analysis. AB 1656 would require all garments sold in California that are made of animal fur to say so on the label. This legislation comes after investigations in the Los Angeles, San Francisco, and Sacramento areas that found unlabeled fur jackets for sale at well-known stores, in several instances being described by the salesperson as fake fur. More than 1 million items of clothing or accessories are sold with animal fur in the United States each year. Under federal law, if the fur value is under $150, it doesn't have to be labeled. The Federal Trade Commission estimates that 1 in 8 fur-trimmed garments goes unlabeled. There is an expectation that if clothing isn't labeled as real fur, it must be fake fur. That's not always the case. In fact, these fur trims are coming from animals like raccoon dog, which is over here, or rabbit, but just aren't labeled. California consumers have a right to know what they are buying. It shouldn't be a mystery. 5 other states have already passed similar legislation: New York, New Jersey, Delaware, Massachusetts, and Wisconsin. With me today is Jennifer Fearing, California Senior State Director with the Humane Society of the United States, the sponsor of this legislation.
Thank you, Ms. Ma. Please proceed.
Good morning, Mr. Chair and members of the committee. I'm pleased on behalf of our nearly 1.3 million members and supporters here in California to be the sponsor of this bill and in association with the Humane Society of the United States. We're grateful to both Assembly members Ma and Liu for introducing this important consumer protection legislation that will enable Californians to ensure that their garment purchases accurately reflect their personal values. I won't belabor it. We are also satisfied that the amendments offered in the analysis will help clarify the bill and advance our intent to make sure that labeling of garments valued at under $150, the fur being valued, is consistent with federal law requirements for exceeding that amount. We think it's an important step forward, and again, we're grateful and hope for your aye vote.
Thank you for your testimony and for delivering it with such speed. Are there any other witnesses in support of this legislation? Are you wishing to speak on the legislation? Okay, please.
Good morning. My name is Jill Buckley. I am here with the American Society for the Prevention of Cruelty to Animals and our 130,000 California members and donors, and we are in support of this bill. Thank you.
Thank you for your testimony. Other witnesses in support, please.
Hi, Nicole Paquette. Hi, Nicole Paquette, a resident of Sacramento, in support.
Thank you. Others in support.
Hi, Linda Wolf. I'm from Fair Oaks, and I represent In Defense of Animals. We are in support.
Thank you very much. Are there witnesses in opposition to the measure?
Move the bill.
Seeing none, it's been moved. Is there a second? Second. It's been moved and seconded. Colleagues, do you have questions or comments on the legislation? Seeing none, I'd like to be added as a co-author, please.
Thank you very much. And I would...
Yes, please.
And I would just like to add, so here is a garment. It's dyed pink. However, this is real raccoon dog. And one way for people to tell, they can burn a piece of the fur, and if it smells like burning hair, then it is real fur. If it smells like plastic or kind of beads up after, then it is fake fur. So that's just a tip for consumers if they want to check their garments.
So perhaps a labeling requirement is preferable to igniting furs throughout stores in California.
Just in case people want to know.
All right. Just saying there's a choice here. All right. So, Ms. Ma, would you like to close?
That is my close. Respectfully ask for your aye vote, members.
Okay. Call the roll, please.
Fear?
Aye.
Fear, aye. Tran? Aye. Tran, aye. Brownlee? Skinner? Hagman? Aye. Hagman, aye. Jones? Knight? Aye. Knight, aye. Liu? Aye. Liu, aye. Monning? Aye. Monning, aye.
Okay, congratulations, Ms. Ma. The bill is out.
Thank you. Thank you, members.
All right, now let's proceed. Is Ms. Saldana here? She is. We'll proceed to item 3, AB 1680. Okay. Ms. Saldana, welcome.
Good morning.
Please proceed.
Thank you. I'm here to present on AB 1680. We are calling this our Hate Crimes Protection Act. It will defend Californians against being forced to waive their legal rights and protections if they are victims of hate-based violence and threats. And contracts for basic goods and services often prohibit settling a dispute in court as a condition that cannot be refused without nullifying the entire agreement. And what this bill seeks to do is allow some voluntary participation in these requirements. There has been a federal case recently where a woman was hired by KBR Halliburton to work in Iraq. She immediately complained of being sexually harassed. Within a short time, she was drugged, raped, and locked into a shipping container to prevent her complaining to her supervisors or reaching out to others that might be able to assist her. When she tried to file a claim against her employer, KBR enforced a agreement that would require private arbitration, and there is now a federal attempt, well, it actually has been signed into a law to deal with that at the federal level. So my legislation deals with a similar situation at the state level. It addresses the application of involuntary or coercive waivers of rights to victims of hate-based violence and intimidation. And I've been working with a group in San Diego on hate crimes and hate speech. We understand the impact of these incidents on our communities. And that's why we do have laws specifically empowered by the people of California to combat hate-based violence through our court system. However, when the availability of that is removed, as in the case of requiring arbitration, sometimes these crimes are not reported, and the Attorney General has set up an annual report of hate crimes. And so one concern is that if these are arbitrated privately, we do not have an accurate accounting at the state level as required by law to see if we are in fact seeing changes, whether increases or decreases in hate crimes. So what this bill will do is still allow a person to agree to pre-dispute, or rather agree in a pre-dispute to waive any of their rights, but it must be a real choice and entered into voluntarily. And if there is a case such as the one that we refer to here and we have witness here to respond to that has to do with hate speech or hate crimes, we want to make sure that, especially in the case of students, that their rights are protected and their safety is ensured. I have two witnesses here. Mario Guerrero from Equality California, who is a sponsor of the bill, and also Lee Kaplan. And in 2003, his son Daniel received some very graphic hate-based death threats from classmates. They are described in the analysis that you have all received. And his case really brought this to my attention. So I'd like to begin with my first witness, Mario Guerrero from Equality California.
Thank you. Before he proceeds, are you accepting the amendments proposed by the committee?
I am accepting the amendments.
Thank you, Ms. Saldana. Your first witness, please.
Good morning, Mr. Chair, members of the committee. My name is Mario Guerrero, and I'm Government Affairs Director with Equality California, the sponsor of AB 1680, the Hate Crimes Protection Act. As you all know, California has laws to protect people from hate crimes, specifically the Ralph Civil Rights Act and the Bain Civil Rights Act. California had, according to the California Department of Justice report 2008, race, ethnicity, religion, and perceived sexual orientation are the three top core reasons for hate crimes in California. Mandatory arbitration prevents a person from seeking redress in court regardless of the allegation, including hate crimes. AB 1680 prohibits contracts from requiring, and that's key, requiring, waiving legal procedures covered under California hate crimes law unless the waiver is voluntary and knowingly entered into. Our bill prohibits refusing to enter into a contract on the basis that a person declines to waive his or her legal rights. It is really important to note that this bill does not prohibit arbitration in any way. We have with us here today an example of the need for such a bill. I would like to introduce Mr. Lee Kaplan, who will share his family's experience, which speaks directly to the need for AB 1680.
Thank you for your testimony. Next witness, please.
Good morning, Mr. Chairman and members of the committee. Thank you for having me here today. My name is Lee Kaplan, and approximately 6 years ago I enrolled my son in Harvard Westlake School in Los Angeles and signed a contract of adhesion with full expectation of the contract's warranties of protecting my son and providing a healthy environment for him to live and learn. After 1 year at the school, a very nice year passed. My son starred in a movie that went to Sundance Film Festival and enjoyed a good deal of success and notoriety, and returned in the fall, starting a school play. There was a fan site that was put up in support of his career as an actor and a singer, and the day the site was put up, a massive series of death threats and hate messages appeared on the site, causing it to be shut down immediately. The messages said such things as, "You fucking faggot, I want to rip your heart out. I'm going to pound your head in with an ice pick. I'm going to shoot you in the chest with a gun. I'm going to push you off the bridge on the 405 and kill you. Fags must die," all based on the misperception that my son, who was a straight individual, perhaps was not. The Beverly Hills chief of detectives who looked at this case said it was the most vicious cyber attack he had witnessed in his 25 years on the police force. The FBI told us that in the absence of knowing who was behind these death threats and hate messages, we were advised to move out of the area, leave the school. We asked the school to intervene and find out who was at the heart of all these activities. We learned later that the school did know who the people were, but covered the names up for reasons that are not relevant to this hearing, mostly related to money. We did move out. We lost our house. We moved to Northern California, after which time that same school, Harvard Westlake, in a front-page article on the lawsuit which we filed against the school, published my son's name. They repeated the hate threats, the death threats. They also gave the address where we moved. And our lawsuit included Harvard Westlake's failure to adhere to the terms of their contract to provide a safe environment for our son. We filed the lawsuit, as I said, but we were forced into arbitration because, as it turns out, there was a small clause in the contract requiring us to arbitrate and to pay fees in case we lost. There also is a California law that says JAMS and other arbitration organizations are prohibited from hearing and carrying out arbitrations where fees have to be paid by the loser, but nevertheless, JAMS didn't tell us of this law and went ahead and held the arbitration and assessed us legal fees for the other side of almost $600,000 after my having spent over $250,000 to that point. I've now spent an additional $100,000 appealing that, and the Court of Appeals has now said that the law firm that assessed those $600,000 of fees can only assess fees relating to things not relating to civil rights violations and hate crimes. As of Monday this week,
I need to ask you to conclude. So go finish.
The California Court of Appeals, as of Monday this week, just ruled that the speech is not protected speech under the United States Constitution or the Constitution of the State of California. Thank you very much.
Thank you for your testimony. Ms. Skinner, you were saying? The bill has been moved. Please, there are witnesses in support of the measure.
Mr. Chairman and members, Francisco Labac on behalf of the American Civil Liberties Union. We are in support of the legislation. This is a narrowly focused piece of bill. These are distinct and unique public natures of these acts are deserving of this enactment of the statute. We urge your support.
Thank you very much. Others in support?
Margaret Johnson with Disability Rights California. We, too, are in support of the bill. We particularly appreciate some of the amendments that were done recently that resolved any of our concerns with the bill. Thank you.
Thank you. Others in support?
Good morning, Mr. Chair and members. I'm Santosh Siram Santana with Asian Americans for Civil Rights and Equality. We are a co-sponsor of the legislation, and we ask for your aye vote. Thank you.
Others in support?
Beth McGovern on behalf of the California Commission on the Status of Women. We strongly support this bill.
Thank you.
Mr. Chair and members, Paloma Perez on behalf of Consumer Attorneys of California, also in support.
Thank you.
Good morning. Diane Segura with Public Advocates. We're in strong support.
Very well. Are there others here in support of the measure? Are there any people who wish to testify in opposition to the measure? Please. Welcome.
Hi, Mr. Chair, members.
You may sit down if you'd like.
Does this one work too? Amira Girton, on behalf of the California Chamber of Commerce, here in opposition to 1680, AB 1680, and no means as a reflection of our denial. These are very serious crimes that are involved in this type of litigation. However, our opposition is focused on the fact that arbitration has been found over and over again to be a fair and effective and efficient and inexpensive means of resolving disputes, and this bill would discourage its use. It has been suggested that arbitration is drastically different from a court proceeding with less oversight, fewer procedural protections, and is often conducted by biased and untrained arbitrators. But the truth is that it's a proven alternative to court proceedings that benefit all parties and the judicial process. It's typically faster and less costly than court trials, with an average court trial lasting about 2.5 years, whereas an arbitration proceeding is concluded within about 8.5 months. The shortened timetable enables all parties to get on with their lives, and it also saves taxpayers money by shifting the burden of those costs to arbitration proceedings rather than courts that are already overcrowded. In addition, the ability to use arbitration is one of the few tools California businesses have for managing the overwhelming weight of litigation costs in our highly litigious legal climate. According to a 2008 study by the U.S. Chamber of Commerce, California's legal climate ranked 44th out of 50 for fairness and reasonableness and has been in the bottom 6 for the past 6 consecutive years. California is also noted on the infamously titled Judicial Hellholes Watch List for the American Tort Reform Association due to its poorly reasoned court decisions that have placed the state citizens and businesses owners in jeopardy of expanded liability. Furthermore, studies have again and again have disproven the assertion that arbitration proceedings are biased in favor of defendants. In reality, plaintiffs fare as well or better in arbitration proceedings as they do in court proceedings. A study of employment cases found that employees prevailed in 63% of arbitration cases, but only 50% of federal district court cases. In another study conducted by the National Arbitration Forum, individual plaintiffs won 71% of claims brought against corporate entities. A study by the American Bar Association found that parties to arbitration are more satisfied than those involved in lawsuits, and another by the Dispute Resolution Times found that 83% of employees favored arbitration over court hearings. Last year, state superior court filings across all case categories totaled over 9.5 million for the state of California. At a time when we are furloughing court employees and in some courts are even canceling all civil cases, to deal with budget cuts, we should be encouraging the use of arbitration, not prohibiting it arbitrarily and against the will of Congress based on assumptions that are continually disproven across all areas of law. For these reasons, we oppose.
Thank you for your testimony. Stay here, if you would, because I want to ask you a question, but only after the other witness in opposition speaks. Ms. Brownsey.
Mr. Chairman, members, Donna Brownsey, representing the California Dispute Resolution Council, and if there's no other opposition, I'm sort of in a third category. Which is that the CDRC originally had a support if amended position. They have withdrawn that. We received the amendments last night, late yesterday, and so I circulate them, to the CDRC board members, and not everyone has weighed in. And I've discussed with both the committee counsel and with the author that we're very happy to sit down and work with them and to give them feedback and address our concerns. The CDRC has also asked me, and this has absolutely nothing to do with the bill, separate from the bill, and to address a few things that they are concerned about in terms of the representation of arbitration and arbitrators in the analysis, with all due respect. And I just want to associate myself with, I think, the representation of the California Chamber of Commerce in terms of the use of arbitration. First of all, California has the strictest and most the strictest requirements for disclosures for arbitration. So in fact, we are far and above a state that regulates arbitrators far more than any other state. Second, repeat players are the lawyers, not the parties. And so the arbitrators work for the lawyers who bring those cases. And so in many and they would say that, frankly, that they know the practice of the arbitrators as well as how they have ruled on cases. And so they are very much distressed at the representation of arbitration and arbitrators as not being professional, not following the law, while there may be contractual provisions that parties have negotiated that allow them more flexibility. We just want to raise those things and look forward to continuing conversations with you and the committee members on the practice of arbitration, and as we said, with respect to continuing conversations with committee counsel and the author in terms of our, we share her goals which is to have a knowing, voluntary waiver. We just don't think these amendments get her there at this point. So thank you for your indulgence. I really appreciate it.
Thank you, Ms. Brownsie. I'd like to just ask a question so I understand the theory of the opposition here, if I might.
Yes.
You stated at the outset of your comments that you felt that this statute, were it to be enacted, would discourage the use of arbitration. And I want to understand why. So here's the premise of my question. So this proposed bill says it ought not be possible for one party to require another in the course of a contract that has an arbitration clause from waiving their right to litigate a hate crime matter. And that's all. That's all the bill does. Why would that discourage the use of arbitration more broadly?
Well, I think partly it goes back to the premise that the whole bill is based on, that arbitration is somehow less fair. And I think there is the perception among people that they want their day in court, that that's how they understand legal disputes will be decided. And so when they get to the moment where something as horrible as a hate crime has allegedly been perpetrated, they feel that that is the place where they need to go to do it, regardless of the fact that they voluntarily waived that right at the time of the signing of the contract. And so our concern is that by deciding down the road that that arbitration agreement that was entered into as part of a voluntary contract is per se involuntary because a hate crime is alleged, it discourages arbitration and it taints it as a second-class citizen to court cases.
Yeah, I guess I'm still trying to figure out, again, I don't want to belabor the point, the theory, because I understand your point that implicit in this proposal is the idea that some litigants, some parties may prefer to litigate in court. And your view is that there's nothing preferable in going to court versus going to arbitration. I understand that that's your view. But why does precluding someone from being forced not to go to court in a hate crime situation, why does that discourage the use of arbitration more broadly? That I don't understand.
Well, I would say actually that they're not being forced. Just because you agree to it prior to the time of the alleged offense, that doesn't mean that you're being forced. This is a contract that's voluntary, and the bill in fact says that the contract it's not being struck down in any other terms. It was entered into voluntarily. It was not, a contract of adhesion, but we're going to decide that this one clause was involuntary because of something that happens down the road. So at the time when you entered into it and you were notified of it because it is labeled well according to the laws of California, it was voluntary. But we decide after the fact it's involuntary, and that discourages people and tells people that something about arbitration is lesser than a court case and encourages them to take it to court instead of arbitrate it.
Okay, thank you.
Mr. Chairman, if I could just add little different argument, which is that there is quite a bit of evidence which suggests that sometimes what happens is that parties who if there's not an arbitration provision in the contract and then would prefer to arbitrate, that usually the stronger party will insist on going to court because they know it's more difficult for the weaker party to find counsel and to pay for the usually higher costs associated with a court case versus an arbitration. But that's a slightly different sort of set than the one, but just it is out there.
Yeah, Again, I didn't want to preempt my colleagues from questions, and my usual manner is to let others proceed. I just wanted to understand but to respond to that point, I think that the proponents would say in response that nothing about this bill precludes parties concerned that they may not be the stronger party in the situation from waiving this right if they wish to. The point of the bill is to allow people that option. All right, now, forgive me for interrupting the flow of what normally happens here. First, are there other witnesses in opposition to the measure or in the nether world that Ms. Brownsie describes herself in being? All right, having said that, Mr. Monning has a question and Ms. Skinner has a question, and others might as well. Mr. Monning.
Well, thank you, Mr. Chair. I want to start by first thanking Mr. Kaplan for being here and sharing what's obviously been a very painful experience for your family and for helping to frame this issue at the expense of your family's peace and harmony. I want to thank Ms. Saldana for bringing this opportunity to us. And I'm supportive of the bill. I do want to offer some comments, though, on my understanding of some of the concerns raised by the opposition. I also read some of the analysis with some concern about what I thought were some summary dismissals of the value of arbitration. I'm a strong supporter of mediation, arbitration, alternative dispute resolution, carried a bill last year signed by the governor that addressed specific issues of disclosure and ethics practiced by arbitrators in the state of California. I'm a strong fan of arbitration, and I believe arbitration works best when the parties knowingly enter a contract where they understand how the arbitration, when it will be triggered, how an arbitrator will be selected, and that it is indeed a fully informed contractual arrangement. We've seen it refined in labor agreements, where one of the mechanisms for dispute resolution in collective bargaining agreements is arbitration. Saves the parties time, money, gets a more expeditious response, and it involves co-selection of arbitrators. I'm also aware in the commercial arena how many of us, and in the employment arena, how many of us sign contractual commitments to arbitration without reading the fine print. Every time we buy a consumer item at a store, a vehicle, a lot of commercial transactions, it's the small print, and we've agreed to an arbitration agreement without really understanding how the arbitrator selected, when it will be triggered. The bill presented by Ms. Saldana today addresses a very narrow arena of perhaps the worst form of conflict that any Californian could face in the arena of hate crimes. We've seen an evolution of law related to the protection of the right to go to court for litigants where a protected right has been violated or is alleged to have been violated: sexual harassment, employment discrimination related to race or age. And what I see this bill doing is protecting the right of somebody who entered a contractual agreement at a school where presumably if the student had to drop out because of illness or they couldn't fulfill a semester under some extenuating circumstance, arbitration indeed might be fully adequate. But when you raise the level of the conflict to something that was not contemplated by the parties at the time they entered that contract as being in the realm of possibility, which I'm sure the Kaplans had no idea when they signed a tuition fee contract that their family would endure what they had to go through. That's what this bill addresses, and I support it with full support, but did feel compelled to share the concern expressed particularly by Ms. Brownsey about the dismissive nature of some of the opinion related to arbitration. Arbitration saves our courts money at a time, saves the people of California money at a time when we have courts closed on Wednesdays. So let's just be clear. This bill protects the right of somebody who is the potential victim of a hate crime to access the full remedies offered by a court of law that are not offered necessarily in a narrowly drafted arbitration agreement. So for that reason, I support the bill. Sorry, Mr. Chair, not really a question, more of a statement, but articulating why I come to support this bill and thank those who have testified on both sides. Thank you.
Statements are welcome. Ms. Skinner.
Thank you, Mr. Chair. Thank you, Ms. Saldana, for presenting the bill and also for both sides in your expressions of support and opposition. You can respond if you choose to, but where I was a little confused by the statement from the chamber around in the opposition is that you portrayed this as well, let's see. I think that Ms. Saldana expressed it as that the consumer does not have the choice, and you expressed it as that the consumer, in effect, does. My support of the bill, and I would basically even support it to be broader, is not in any way a non-support of arbitration, but rather an acceptance of the simple fact that such contracts as the contract that the gentleman had to enter in the school, or that I as a consumer have to sign when I buy products, I don't have the choice to negotiate those contracts. Those contracts are form standard contracts. And you either sign it or you don't. And so what I feel is appropriate is that while there's preference for arbitration, but that there not be an automatic exclusion that the only option is arbitration, because you as the contract signer have no choice but to do that. because you don't have the ability to negotiate the contract. So I guess if you want, you could respond to that or not.
I'll answer briefly. I guess I'm just referring to, in contract law, what we typically say is you have the right to shop around. So if a place offers you a contract and has an arbitration agreement and you don't want to sign it, you're welcome to get your services elsewhere. There's more than one private school in California, so there's other places you can look. But we do have an entire body of contract law that involves adhesion contracts, which says if it's a necessity, so medical services at the time of need, they cannot force you to waive rights at that moment because you really don't have a choice then. There's nowhere else you could get the service when you're facing an emergency. Since this is not such a choice, you at that moment have the time to shop around and find a place that will give you a contract. It's true, you probably can't negotiate with that school, but that doesn't mean you don't have alternatives and you don't have choices, and that's all I meant to say.
And just for the record, I did make the motion to do pass as amended.
Yes.
And I would also further ask Ms. Saldana if you would add me as a co-author.
Thank you very much, Ms. Skinner. Other questions or comments from members of the committee?
If I may, Mr. Chairman.
Mr. Tran.
On this issue, which is a very important issue, concerning relations or contractual relations and transactions between parties, first of all, I share Mr. Monning's opinion regarding arbitration and mediation because as lawyers we all always agreed on the fact that if we can save the client's expenses and save time, which is also money, that's very important. And as someone already said, arbitration laws, the body of laws in California has been very stringent. I do have concerns regarding this legislation, however, and that's not regarding arbitration, but it's the issue of privity of contract from a pure standpoint, and that is you have parties, private parties making a contractual relationship between themselves or among themselves. The question, perhaps a rhetorical question, is why is the government entering into this contract from a very draconian standpoint and trying to prohibit or preventing the execution of this contract, given the fact that we already have case laws or case precedents that deal with contracts that are unconscionable or one-sided. Perhaps someone can address that issue, and if that is a concern at all on either side.
I would respond. I'm an attorney as well, and I was a federal prosecutor before I was a filmmaker.
You should have disclosed that at the outset, so people were warned. Yeah.
I'm sorry. You're warned now.
No, please.
But I think that when you drift into the realm of violation of your civil rights, I think that you have drifted out of the realm of what the contract originally contemplates. And I think that's what answers your question. I don't think in a million years it ever would have occurred to us in shopping around, as the young lady said over there, for this private school or that private school. I would wager that all those private schools have the same thing, that you should arbitrate whenever possible. And I'm not in opposition to arbitration at all, for all the reasons that were mentioned in a positive sense at this hearing. But when you drift into this area of violation of someone's civil rights and you threaten their life, I do not believe, under any stretch of the imagination, that it possibly can be handled in an arbitration situation where the arbitrator may not even be a lawyer. It may just be a business person. They may not understand the limits that the Constitution imposes on behavior among people for race, color, creed, national origin, or sexual preference. Those are very sophisticated things. And since the time that our case began until now, there has been a rise in deaths on school campuses, sometimes from people as young as 8 or 10 years old. And in my home state of Virginia, in southwestern Virginia, someone warned over and over again on the web they were going to do this, they were going to do this. No one paid any attention. Then that person did it, and many people died. And I don't think that this in any way fits the model that you've presented today, with all respect.
Thank you, Mr. Tran. Others with questions or comments? You know, I just want to add along these lines, you know, I actually have mediated cases myself. And so I know contexts in which that occurs from very personal experience. In this situation, the parties to a contract to enter into Harvard Westlake School could be contemplating disputes like this. I didn't pay my tuition on time, or there's some dispute regarding a grade, perhaps, or something of that nature. I don't think in a million years someone, as Mr. Kaplan indicated, shopping around for a school would contemplate that they would not take it, that they'd be put into a situation where this would have to go to arbitration. Now, the response is, but Mike, implicit in your point is that there's something less good about arbitration. And I would say that an arbitrator called into a situation involving Harvard Westlake School's contract is likely to be an arbitrator with a certain skill set. Someone who's capable, for example, of dealing with commercial disputes around the payment of tuition, for example. This is an entirely different matter and requires a different skill set. And I don't know that this differs from what others have said so far about arbitration, but I will say that there is something meaningfully different, potentially meaningfully different, about the training that a jurist has in a courtroom to handle a matter of this nature and the training that an arbitrator who is used to dealing with commercial disputes of a different nature would have. So I do have concerns about that, and I would strongly, from my again, having done this work, again, mediation, different from arbitration, having done this work myself, different skill sets, I have to say. So in any event, I am a supporter of the legislation. I would like to know if Ms. Saldana wishes to close at this point.
Well, thank you all for your questions and your comments. Mr. Monning, I feel the same way. We need to focus on a remedy, not so much the process, which is really best dealt with, as you've done in a previous bill, as far as arbitration process. The idea that someone could shop around for a better school and somehow ask, would my child be subjected to death threats at your school? I don't think that comes into the minds of any parent who is looking for a school for their child, and private or public. And yet we are dealing right now with some things happening on campuses, our public campuses, that are raising the question of how safe are our schools and how do we respond and how do we make sure that our children are in a safe environment for their education. So I think the 3 points that I'm looking at in terms of the arbitration question, is it timely, as the opponents of this bill say? Well, in terms of public safety, protective orders, restraining orders, I don't know that arbitration is set up to have a timely resolution that would satisfy the concerns of a parent whose son has been threatened with death. The cost, we've heard testimony that this family has spent hundreds of thousands of dollars and has yet to really believe that they have reached a satisfactory outcome. And then we get to the outcomes. This is beyond the outcome of a private contract. And with respect to Mr. Tron's question, I agree in certain contractual agreements that it should be kept private. But in the case of public interest, with regards to hate crimes, it's very clear the state has an interest in disclosing these types of incidents when they occur in the interest of a broader public safety issue. And so if we want to ensure an accurate report to the Attorney General's office related to hate crimes, if we want to ensure safety for our children on any campus, private or public, if we want to ask, should minors be subjected to, if their parents as adults sign a contract, does that remove certain protections for children? I think any parent would say, absolutely not. I would feel awful if I signed a contract that put my child in harm's way without any recourse. So those are the questions that I think we are trying to focus on very specifically in this. And the other issues, I welcome to work with the opponents to come up with some agreements on some of these broader cases that are of concern. We already did that with regards to the disability community. But this is, as every bill, a work in process. And I think it is an important one because we are seeing an increase in this types of behavior on our campuses, public university campuses in California. So with all that, thank you very much for your thoughtful questions and comments, and I ask for your support to protect the legal rights of people who have found themselves surviving these types of threats and of violence and intimidation.
Thank you very much, Ms. Saldana. Call the roll, please. Oh, we need a second. Excuse me. Is there a second? It has been seconded by multiple parties.
Fear?
Aye.
Fear, aye. Tran? No. Tran, no. Brownlee? Skinner? Skinner, aye. Hagman? Hagman, no. Jones? Jones, aye. Knight? Knight, no. Liu? Monning? Aye. Monning, aye.
That bill is on call. It needs 2 more votes. Thank you very much, Ms. Saldana. All right, now we are proceeding to our final matter of the day, and that is AJR 37 by Mr. De Leon. Mr. De Leon, welcome.
Chairman Fuhrer, good morning. Vice Chair, Mr. Tran, as well as members on both sides of the aisle. Good morning. I'm glad to be here. Tell me when to proceed, Mr. Chair.
Pardon me? No, please. Go ahead.
Thank you very much, Mr. Chair. Thank you to my colleagues on both sides of the aisle for the opportunity to present Assembly Joint Resolution number 37, a measure that would urge the President as well as Congress to take a comprehensive and workable approach to improving the nation's immigration system. California is home to approximately 2.9 million undocumented immigrants that arrive to the United States from various countries from throughout the world, whether it be Mexico, India, China, Ireland, or Canada. These are individuals who live, pay taxes in many instances in the state of California, as well as elsewhere throughout the nation. These undocumented immigrants are our neighbors, they are our friends, they are our family members. Last year, the President decided to delay immigration reform until 2010. Now we're in 2010, and we still don't have immigration reform. We need to urge the President as well as Congress to push through these reforms and fix our broken system once and for all. The last time Congress addressed this issue comprehensively was in 1996 when then President Ronald Reagan was at the helm of this country. 24 years later, here we are still stuck with an antiquated and, quite frank, dysfunctional system that breaks families apart. Our immigration system needs more than just a facelift. We need to modernize the system by creating a pathway to citizenship for the millions of immigrants working and living in our country and our state. This is a measure that is sponsored by the Coalition for Humane Immigrant Rights in Los Angeles. I do understand, and I'm very well aware that immigration is a very polarizing and polemic issue in the state of California. I always look forward to engaging in a very thoughtful, constructive dialogue on this issue. Therefore, Mr. Chair, as well as Mr. Vice Chair Tran, I respectfully ask for your aye vote.
Thank you, Mr. De Leon. Your witnesses, please.
Good morning. My name is Angelica Salas. I am the Executive Director of the Coalition for Humane Immigrant Rights of LA and of the California Coalition to Reform Immigration for America. It is imperative for California to voice its support for comprehensive immigration reform because California has the most to gain with the passage of immigration reform and the most to lose with the status quo. California's immigrants comprise a third of the state's population. Immigrants and their children, nearly half of California's residents, and 2.9 million people are undocumented in California. 1 in 11 workers in California is an undocumented immigrant, and approximately 77% of undocumented immigrants that reside in California live with family members that are legal U.S. residents and citizens. Together, immigrants of all statuses contribute to California's vibrant diversity and to state and local economies. CIR is a key ingredient in economic recovery. We're in the middle of the worst financial crisis since the Great Depression, and no state has been more impacted than California. A full recovery will take and encompass many factors, including comprehensive immigration reform. States with higher number of unauthorized immigrant workers see a greater economic benefit. A study by the University of Southern California indicates that in the long term, California could see $16 billion annually in boosting the economy as a result of the enactment of CIR. I actually brought a copy of the executive summary so you could review it. The Conservative Cato Institute agrees and also suggests that legalization of low-skilled workers would yield significant income gains for American workers. Yet the only immigrant policies that have been implemented thus far are enforcement-only policies. The immigration enforcement practices of the past administration, pursued by the Obama administration, continue to tear California families apart. We're impacted, our families are impacted, our businesses are impacted as more enforcement goes in the work site, impacting both immigrant workers and native-born workers as well. CIR would ensure a legal workforce for employers and would create a level playing field by instead focusing on unscrupulous employers who deliberately flout labor and immigration law to exploit workers and to cheat them out of wages and the state out of tax revenue.
If you could conclude your testimony, please.
Sure. California has a choice: support comprehensive immigration reform and look out for its self-interest, or continue to be socially and economically penalized under the current immigration system.
Thank you for your testimony. Other witnesses in support, please.
Good morning, Mr. Chair and members. Vanessa Kahina on behalf of the California Immigrant Policy Center. We're here today also in support of AJR 37 for the reasons that millions of Californians currently cannot contribute their full potential to our state's economy and communities. For the reasons that Ms. Salas so eloquently stated, we support comprehensive immigration reform and hopefully can request your aye vote. Thank you.
Thank you. Others in support?
Thank you, Mr. Chairman. Park Terry on behalf of the California Landscape Contractors Association. Our association represents about 3,000 licensed contractors in California. We've been dealing with this issue since 2006, and we've been very active both in Washington, D.C. and here in Sacramento promoting immigration reform. And I just want to give you the sense in the business community that this, particularly service businesses, that this is a vitally important step to take.
Thank you
Many
very
of the
much.
employers simply are stuck right now between risking actions for discrimination if they hire accidentally an undocumented worker, and at the same time we're simply perplexed as to how to run our businesses without these individuals. So we urge support of this resolution.
Thank you. Others in support?
Good morning. Erica Romero with the Hispanic Association of Colleges and Universities in support.
Santosh C. Ram Santana with Asian Americans for Civil Rights in support.
Thank you. Are there other witnesses in support? There's no opposition on file, but are there witnesses who wish to speak in opposition today? Seeing none, questions or comments? Mr. Monning.
Thank you, Mr. Chair. I just want to thank Mr. De Leon for bringing this resolution before us. I was particularly pleased to see the explicit reference to the ag jobs legislation that's been languishing at the federal level. This represents, I believe, a critical step forward towards broader immigration reform. It represents a coalescence of agreement between ag employers and farm worker representatives, the United Farm Workers Union, and that is historic. The fact that employers and employees have reached agreement on how immigration reform could lead towards a planned process towards legalization while respecting family unity, family integrity, and bringing everybody, not just employees, but also employers, out of the shadows. So I just want to applaud you for bringing this forward. As my full support, I'd like to be added as a co-author. Thank you.
Thank you, Mr. Monning.
Thank you, Mr. Monning. Others with questions or comments? I believe it to be the case at the federal level that just last week, Senators Schumer and Graham, I believe, came forward with a joint bipartisan effort to move this same ball forward. All right, Mr. Jones.
Support the author. Would like to be added as a co-author.
Thank you very much, Mr. Jones. We did receive your written notification for authorship, co-authorship. Thank you.
Thank you. Other questions or comments? If not, Mr. De Leon, do you wish to close?
No, thank you. I'll be very brief. I know this is a polemic issue across the nation. I'm hoping that we'll come to a consensus and a conclusion sooner rather than later in Washington, D.C. We know that health care is a big debate that's raging right now. What happens with health care will play a big part in what happens in major bills in the future. I'm just hoping that Republicans and Democrats can come together. It's a quite interesting fact. I'll just leave on this note that the biggest immigration reform packages in political history have been, interestingly, spearheaded by Republicans. The last one being Ronald Reagan, and then U.S. Senator Pete Wilson, who was largely responsible for the legalization of what you call the seasonal agricultural workers, because we have the largest, most comprehensive, complex, and sophisticated agribusiness in the world. So with that matter, I will definitely reach out to my colleagues on the Republican side to see how we can come together on this issue. Thank you very much.
Thank you very much, Mr. De Leon. Is there a motion? Second? Yeah. Okay, I think we have two movers, so we'll take that as a second. Okay, call the roll, please.
Pierre?
Aye.
Pierre, aye. Tran?
Not voting.
Brownlee? Skinner? Skinner, aye. Hagman? Hagman, no. Jones? Jones, aye. Knight? Knight, no. Lou? Lou, aye. Monning? Monning, aye.
Okay. That bill has 5 votes. We'll put that on call. We know that Ms. Brownlee is serving in a meeting, in a hearing concurrent with this one. We'll spend just a moment while she makes her way here, and then we'll lift the call on this item and also on the previous item.
Thank you very much, Mr. Chair. Thank you, members. Thank you.
I'm going to wait. All right, we're prepared to lift the call on item 3 by Saldana, AB 1680. Please.
4-3, chair voting aye. Brownlee? Aye. Brownlee, aye. Lou? Aye. Lou, aye.
Okay, that bill is out. And item 4, AJR 37, lift the call, please.
5-2, chair voting aye. Brownlee? Aye. Brownlee, aye.
Okay, that bill is out. Colleagues who were unable to be here previously may add on to other matters if they wish. Otherwise, we are adjourned.